term was thrown, even our experts were starting to speak by our previous speaker, and the question was where the role of the lawyer in preparing the expert presentation in the hearing or working with the expert is crossing the line and becoming an interference in the work of the expert. And that was the question at the beginning. So if I may ask this question and ask whether one of our experts here might wish to give an answer.
The expert's opinion is the expert's opinion, which gets back to Geoff's last point. There is no harm at all in the client or counsel presenting facts to the expert for their consideration. But it's up to the expert as to how they take those facts and produce their opinion. I think that's quite clear. I mean, this is one of those things where I think a lot of common sense can be brought to bear. If the way that your counsel or client is putting things to you, you get an uncomfortable position, then I think you've gone over that point. But I think, you know, in terms of a lot of experts, they develop their opinion in already in terms of the report, and should know facts and circumstances well, which they can have a discussion with their own client and their counsel, who legitimately may be challenging them, but as long as they can justifiably defend their position and not get swayed, then I think that challenge is also okay. You know, I don't know how you might.
I think it's part of the expert's duty to consider all material facts, and so when we're being cross-examined, if something comes up, we must consider it, and it may cause us to change our view, and it's our job to do that, to say, just let me think about this for a while, but yes, that does it. So that's always our job. It's therefore, I would say, it's quite right for the challenge to go out. In my experience, I've had a court report sent to me, Geoff. We've read what you say in chapter 3. We'd like you to reflect on paragraph 74 to 79 in this judgment. I'm perfectly comfortable with that. And I don't particularly recall if it changed what I thought. You possibly did. But that, to me, that's fine. There's no problem with challenge. The problem is when the pressure comes, so what I'll say to you is my biggest expert appointment was a 2.5 billion euro dispute on a nuclear power station. I had 24 people working for me at Hill International. A lovely big fee that we were earning a fortune. And I was called in by the lawyers, who you all know, and I won't say their names. And they said, Geoff, we want you to think a bit differently. Oh, really? And they put it to me and they explained how they wanted my analysis to run. And I said to them I was uncomfortable. They said, we want you to come back tomorrow at 3:30 and tell us whether you will adopt this method of analysis. Okay? So I went back to my office, Tony Hunt, I think that you know. And this is Andrew, your point, the expert's opinion. My boss said to me, Geoff, it's your opinion. That's what counts. If you can take that up, that's fine, if it's your opinion. So I went to them at 3:30 and I said, I won't do it. And they said, don't worry, you won't have to because you're not the expert. And so me and 24 people were off the payroll. But that's actually one we much more work than it ever lost me. Because it demonstrates my independence. We need to be independent. Challenge is fine, but we have to adopt that position. And it's exactly right. I'm giving my opinion. It's almost to a point, it doesn't matter if my opinion is wrong, as long as it's my opinion. That's what I'm there to deliver. It can be found someone who disagrees with my opinion, it must be my opinion that I do.
It's based on facts that you gathered, to introduce together facts, we had a case which I'm giving as an example from missing facts, where on the company website there was a contractor which was listed as projects in the pipeline. Projects in the pipeline, and the argument was finalized the project, but on the company website there were listed projects in the pipeline. So the question was, we need to do the council is to make it very clear how, on which basis you substantiate on facts, and for them to understand why that, if they may have a different view.
In terms of preparing for an arbitration, or even when you're producing a report, there is a lot of discussion between you, the client, and lawyers. Because one of the key aspects of the expert's job is to help lawyers understand the damages position, whatever it might be. Because at the end of the day, they will be doing the cross-examination, and they need to understand the subject matter almost as well as you do, if not even better than you do. I'm always impressed by legal counsel knowing the damages better than we do. I mean, we always take solace that we're the expert in the subject matter, not the lawyers, but it does seem that might not be the case at sometimes. But during that preparation, there will be a lot of discussion, and you can see how counsel is saying how they're getting to grips with the issue and understand the position. And they might come back and you say, well, I think I understand that. What happens if you do A, B, or C? And you'll say, well, if you do A, B, or C, then this will happen. Well, how does that differ to what you're putting forward? Well, that's because you've got issues D, E, and F to consider as well. So that is perfectly okay in terms of that discussion to help your legal team understand the damages report, because at the end of the day, their job is to discredit and make the other expert look foolish, dare I say, undermine their credibility.
I would have a question. My name is Andrei. I'm one of the master students, probably. Alumni, and my question aims to summarize all the discussions. And it looks like this. We as counselors, as lawyers, are usually taught how to dismantle European, how to cross-examine. There are famous those 10 amendments with further issues, how to dismantle European, how to cross-examine with several rules in 10, 20 or whatever points. From your point of view, from the other part, which would be in 10 or 5 to 10 points, your commandments in order for your opinion not to be dismantled. 5 to 10 points to be followed in order for your opinion not to be dismantled by the cross-examiner. I think this is summarizing whatever we discussed this evening.
Before this time, I guess.
Know exactly, and we will not forget to be to the matter. So, if you know your topic and you are very confident about your opinion, then nobody can dismantle unless it goes, and there is some missing fact. I mean, it will be rather difficult to dismantle because you are there knowing and having supported good support.
I would say the first one is to be grounded in facts, because that's what we're called upon to do. We're called upon to understand the facts and then bring our technical expertise to those facts. The second one is to stay within our expertise. Now, the easiest one to stray from is to start explaining the law to you. That's the easiest one to do. We fall into that. So when we do that, we always say, "Well, I'm not a lawyer," and then we do it. But stay within our expertise. So if you want to have a go at an expert, show that he's moved away from his expertise. Be ready to consider new facts when they come forwards, and that can occur firstly in expert meetings. Andrew Clark said, I think the joint statement that we certainly use in the UK, where the experts, we first of all draw up points of agreement, the experts agree. Doesn't mean to say the tribunal will agree, but the experts agree. So it says you don't need to read chapter 5 of my report or chapter 7 is because they say the same thing. That's good. And then there's the points of disagreement. So in the expert meeting, we do need to be ready to consider the other expert's point of view. Often he has access to facts that I have not had access to, and consider the weight of those facts. So I think a readiness, and certainly if we ever read a judgment, the judge respects that this expert was ready, not necessarily that he did change, but he was ready to consider new evidence brought before him and to let it influence his opinion. So I think a readiness to change, and then I do think being prepared, the unprepared expert, and the best one, the top experts have fallen typically when they've taken on too much work and they don't have the time to be fully prepared. We often have to rely on teams. I said to you on the big job there, I rely on team, and then I don't really know about the things which are in my report. I have to know every dot and comma that's in the report, because that's the only thing you get to see. You don't know about the other things I don't know. But if you go to a large tranche of the expert and start a report and start taking it to pieces, and I'm saying, does it say that? That's
and be honest.
Yes.
You have to be honest. Be honest if you don't. And cover that. Not try to cover that.
I think I may have 5 points. Give myself 5 points. For the expert, the most important person who asks questions is the tribunal or the judge. So if there's one person you listen to more intently than anybody else, it'll be the tribunal or the judge. In second place, other lawyers. So, in fact, your own lawyers, when you're being re-examined at the end, those are critical questions that you've got to concentrate on. Just when you think you're out of there and you've finished the cross-examination, you have your counsel doing re-examination. That's the second area that you need to concentrate on. The honesty is agree obvious points that you should agree to, which might go against your opinion, but if it's that obvious, you should be agreeing to it. Understanding, it's probably going to be on a very minor point, but if there's something that you've missed, or you've misunderstood, or there's just something that the question's put to you, yeah, that's obvious, I should agree to that, that's, it's a fair point in terms of what you're saying, you should agree with it, I think that helps your credibility. In terms of preparation during the tribunal hearing itself, read the transcripts very carefully. The one difficulty if you're an expert is when you can see the questions coming, I had such and such in here 3 days ago, and it said something which appears to contradict with the facts on which you based your opinion. You need to give yourself time before you're actually in the witness box to understand what the consequences of that are. Normally your legal team are pointing those out to you, but reading the transcripts yourself, it makes for some very late nights, unfortunately. It's key in terms of your preparation. And also visit the hearing room itself and listen to the actual witnesses. It gives you a chance to see the style of whoever's going to be cross-examining you. It might be that the person you're seeing do the cross-examination is not the person that's going to do the cross-examination of you, but at least it gives you a feel as to how they're doing their cross-examination. This recent hearing, I think it was Laura who said he always starts off with a question about your CV. Now, of course, I will read through my CV every time I go to the witness box. But it might be something you take for granted. But with that, I did go through my CV very carefully the night before. And he raised the question about the relevance of a case, and I was able to explain it was very relevant, which unfortunately he wasn't expecting. But it helped considerably just getting that understanding as to the feel of how they're going to do the cross-examination. It is very important. The last one is in terms of preparation. Before you send out your report, you need to have that internal check that you're not missing anything. So bear with us when we're producing our reports and we're saying, well, I've got to do a few quality control checks at my end. That quality control is someone from within our own teams who's sort of a seasoned professional doing a mock cross-examination almost of your report before it goes out the door. Do you really think this company is valued 0 at 0 when the other expert is saying it's worth 300 million? Are you sure, Andy, that it's worth 0? But having a few pointed questions as to where they see that you might be able to, where the other side might be able to chisel away at that 0, because at the end of the day, I mean, this is a particular example, but if you said the answer is 0, and under cross-examination they moved you from 0 to 1, who cares that the side is saying it's 300 million? You're off 0, and then they start chipping away, and you lose the credibility. So having that internal cross-check before you send out the report, I think is very important.
Could I just say just one last thing, though, is as an accountancy, what you don't need is to be able to count. Because Andy said we had 5 and that was 7. There were subcategories. Counselor told me about subcategories.
I want to stick with that.
It was a second question.
My name is Alexander and I also am a manager of this LLM, and I would like to ask you 2 questions. First of all, in case you were talking about experts on each side of the parties, what about, and did you encounter in your professional experience, the situation when you have 2 experts in the same team which do not get along in terms of ideas and conclusions, and the deviation from this would be, are the counsels also sometimes considering a counter expertise with the home expert? That would be my first question. And the second one is also it's linked to what Geoff was mentioning regarding looking at the CV of an expert. And in view of international commercial arbitration, which it's a very complex but also worldwide type of arbitration, how do you find the experts? I mean, which are the most used channels for finding the experts? Because you might have a part from, I don't know, an African country with a partner from Europe. When you need a lot of experts, some of them might have to know some languages, apart from the expertise. How do you, which are the channels? Apart from the, I suppose, and the word of mouth.
Ladies
Been in a situation where we had 2 experts, but to be honest, I mean, the opinions of 2 experts were pretty constructive, so we were not disagreeing, although we may have had different opinions. It was for the benefit of the legal counsel that constructively we did that, we had shared different view and commonly jointly reached to clarify the matter. So it was constructive. It happened to us because we were brought in a bit later than the original expert, so we were coming along to, if you like, to bring an additional expertise, but we have had a similar case, whereas it started, it was brought in a bit like 6 months later, but in the end we managed to, doing the hot topic, because we were on the same side, we managed to jointly conclude and help on the case. It was not in disagreement, but it happened to us. It was different times when we were brought in. Not at the same time, because that's a bit strange to unless we have different areas of expertise where, if it's a regulated industry, for example, you want to have something where things are okay, or regulated or specific, where for those difficult industries where you require specific industry, where we, for example, were lacking to some extent, so we needed that input. But that was purely expertise, not necessarily the same level of expertise in debate.
Was the question whether you've got 2 experts on the same side, on the same subject matter? That works. It happens rarely. If you do, normally it's because someone's taking over from someone else. You know, to get back to Geoff's example, someone doesn't like the opinion, so they'll change. Where I've seen it sometimes comes into play is where, to go back to your point about different disciplines, where you might have an economist and an accountant looking at There is a degree of overlap between economists and accountants, but there are areas around the edges where they don't have the expertise of the other. And in terms of how they might approach the issue can be very different. We do at the moment a lot of work in competition damages where you have accountants and economists working together. The economists, I'll say this because I've got economists in the team and they know this is my view sometimes how they work, are very theoretical, and sometimes you need to bring the actual facts of a situation to bear on in terms of how the damages are calculated. Because you can have all the wonderful theory in the world and you have to base that on assumption, to go back to my earlier discussion. But sometimes that doesn't bear resemblance to what the actual facts are in terms of what you're trying to calculate. I mean, to give you an example, this isn't between economists and accountants, but between engineers and accountants. And to go back to your SDP, yes, there was a very large dispute in the UK regarding the new MOD building which was built down near Bristol. And the contractor was Molan, and the employer was the MOD, obviously. And someone had, I won't say what the profession was, had put together a calculation for moving a toilet 90 degrees. And they had worked out that it had cost £5,000, and that was the figure that they put into the claim.
Very cheap.
Very cheap. Until someone who said, well, I did that last week, and it only cost £100. And you sometimes get that difference based on that, but that's, you just need to be careful as to, if you've got experts in different disciplines, they will approach things differently, and you just need to recognise that.
The time that I've seen, first of all, I've not been involved at all where testifying experts on the same side of the testifying experts. If I carried on, because I was bored, so you must have been. I got two slides. The other thing we often do is we act as advising expert. We're not going to be the testifying expert. And you mentioned about early involvement. Definitely advise. We should all respect each other's skills. And at some point you are lawyers, and these guys are accountants. And you may want early advice from the accountant. How does my case look? But you may not want, you may be ready to take on appoint an expert. So and I'm sure you do as well, you act as advising expert. Now I have been in this situation where there's been an advising expert on board, and then I come on board, and I start to give different advice. And now the client, in that situation, was paying two people, paying us both, to argue with each other. Good business, but not very good things. So that's when I've seen that tension. I think the other thing, I'd say two things on CV. The person that needs to know their CV most is me. Because before I say I'd like to do this job for you, I have to decide whether I'm an expert, because I have to stay within my expertise. So I need to know my CV. And then in terms of for you, I think you should bear in mind the jurisdiction that you're working in. If you take on Andy or Cornelia or I, you've heard us all telling you about how we operate independently. Now if you use us in America, the judge is looking at you as you say you're an independent expert, and he's expecting you to be biased. So if you turn up and are independent, they'll think, it must be a weak case. So as lawyers, you genuinely have to think about that's very similar in the Middle East, especially in smaller matters. People aren't really expecting the expert to really be independent. They're expecting him to be very partisan while he's independent. Come to the UK, and in the court, if the expert is seen to not be independent, he will be cut to pieces and his career will be over. So you need to think about the jurisdiction that you're in when you pick up this CV. And you may be saying, will I be able to get Andy Grantham to operate well for me in the US? You may, I'm not saying otherwise, but certainly just have to think, what is the court actually thinking when they're looking at this expert?
Certain questions about the process where you have the first source of information would be for accounting expertise or accounting experts or economics on past cases, and there are some names listed, which represent, not always.
Colleagues.
Then, internet you do, and there are companies' websites, I'm sure it's good athletes coming from that would have professional services.
That's my question. And that would be the second last question, because I have saved some room for one last question on my own, if you accept that.
Thank you. Was there a situation where a barrister impressed you with how he used your opinion as an expert, although it was not in favor of him?
Could you please repeat?
Louder.
Was there a situation in which a barrister managed to impress you as an expert by using your expert opinion, although it was not in favor of him? He turned the situation in his favor, although your expert opinion was maybe not in his favor.
I would think that it is, to be honest, I think so. I think you're suggesting that I set out my opinion and I explain a certain thing, then the barrister, presumably either from my side or the other side, turns it to make it look like something else. I would only say, really, first of all, I don't think I have any. My duties to the tribunal, I'm not sure that it's over, just I think it's my duty over when I've been more or less not sure my duty to go to the tribunal and say that that's been executed. Yeah. I think once I've given my evidence, he can do with my evidence the same as he can do with everything else. I mean, the barrister turns every letter and...
Yeah, but how he played a situation in which he impressed you, not the tribunal.
He impressed me.
Yeah.
And changed my opinion.
Well, maybe, yeah, although you gave your opinion.
I think the cross-examination, and I'm not aware that this is in terms of what an expert is told as to how the cross-examination works. The barrister or the lawyer wants to tell his story, wants to get you to agree to his story. And to the extent he can ask you questions whereby you agree to something, because at the end of the day, most of this is he just wants to get snippets on the record that he can put into his closing submissions in terms of how he wants to argue the case, having heard all of the arguments in testimony. So all he's trying to do is to get you to agree to various points that he wants you to make, so that he can write his story that supports his client's position. And that's, you know, the clever counsel of those who are getting just the right bits of information to put into their story. If they start going down roads and you can, a key point is when the barrister or lawyer says, "I'll come back to that," because I don't know what these guys' experience is, but when the lawyer says that to you, giving something away here, you know you've won the point, and they will never come back to it. So they'll go down a different line of questioning. But it's simply they want you to agree to their story, and they will pick out the relevant bits in your report which help them agree. It might be only small bits. It might be that they just want to give the tribunal the impression that you're agreeing to all of their points. But so he might just be picking on small points for you to agree with. But again, he might just be wanting to give that impression.
Yes, that's what I want to hear.
Yeah.
But changing your opinion, it's only based on the new facts. I mean, you can't, if you get all the facts, and it's not just the impression, you are not going to change your opinion. I mean, you lose credibility, and it would be very awkward to change your opinion just because the lawyer, only based on the new fact that you may want to consider that you may change your opinion, then you, like you said, you may want to pause that and say that I need to consider that or not. It was not known to me or something like that.
So the last question that I
if he wants to make you feel uneasy, and this happened the last time I was cross-examined, Mr. Bewsey, you say you have taken account of all material facts. Yes. You said that you have considered all of the progress minutes. Yes. Can I take you to? And he says, so if that's written there, how can you say this? Now he achieves two things, if indeed he's right. You know, I can't think of my feet. You said you considered this, Mr. Bewsey, you think I'm sure. But he can achieve really, if he can show, actually this guy said he looked at everything and he clearly hasn't. That's a good way to take it out. A lack of readiness to, if I start going defensive and try against what I'm reading, I unreasonably try to defend my position. That's a good way to take me out. Yeah, I think that's probably there, I would say.
The next one is accounting expert. You ask to get prepared for cross-examination, so that would be, because you would have under those points where you would really put really input the problem get prepared, stay there for the lunch from legal standard, get those arguments and try to prioritize your cross-examination so that you can easily, I say make the good use of the time and emotional impact, because that helps.
It's almost a question I'll throw back to the lawyers, because for the accountancy side, we will produce probably some very large spreadsheets with a lot of numbers and a lot of assumptions in. And I think a good tactic for cross-examination is actually to pick on some of the detail in the spreadsheet and see how well the expert understands it. Because you probably have a team putting together the spreadsheet. Are you familiar with all of the detail in all of the work? I mean, it should be a memory test, but it is. That would be, for me, a good way of testing the expert and testing me as to, okay, this point here, Mr. Grantham, because you've now, the expert on the other side coming in and going, there's an error here, get him on that error. And it may have to just be a simple logic error, but there's still an error there. Yeah, but for some reason, I'll let you form your own opinions. The lawyers are very reluctant to get into the numbers, so they don't do it. Now, for legitimate reasons, it might be because to actually prove to the tribunal what this issue is and then the consequences of this issue, because there is an error, you just don't have the time to do it. So there is a tactic there, but I think sometimes it would be well worth exploring it to try and put the expert on guard, because they won't be used to questions like that. And if there is a genuine error there, then they're already on the back foot. There's an error. What else is there? Where else is